Small claims against big names. On Sunday, April 24th, 2022, this is Orthodox Easter. Happy Easter, everyone. Second time around. If you missed it last week, well, the Lord has risen. Praise the Lord. Emmanuel is his name. Look at, taking the United States to small claims court. It's something I was trying, and I was waiting to see what happened. And, well, now I have a court case in small claims that we're going to talk about against the United States for forcible entry and detainer. And, why I did it and everything is what I hope to show in this video. So, I'm Staff Sergeant Robert Allen Ritluski, U.S. Army veteran, also known as Rob Ryder. And if you wanted to contact me, the easiest way would be through my email, which is courtofrecord@aol.com. Right, no S's, just courtofrecord@aol.com. I have to admit I'm not really good anymore about getting back to everybody. Just a little bit too busy. You're going to have to forgive me, right? So you may have to do it more than once. But anyway, so, how can you take the United States to small claims court? Well, you do it by filling out the forms. So let me get a few things together and we'll talk about this. Hang on just a second. So if you have been following along, some time ago I did a video called Finding the Lesser Magistrates. Well, it's 5 months ago now, cheapers. And then I do a little correction because I made a mistake on what the seal actually said, which says something to the effect of the District Court of the State of Michigan, right? Because in Michigan there's supposed to be one district court. And what I was trying to do in these videos is to file into the District Court of Michigan, which now the district court's broken up into judicial districts, right? And so, like I'm in the 63rd Judicial District. But there's really just one district court. However, when you look at the building, it says the 63rd District Court. It doesn't say the 63rd Judicial District Court. It just says the 63rd Judicial District Court. So it's really not the court of the United States of Michigan, right? Not the one that's talked about in the law, because in the law, it's, there's one district court, and it's broken into many districts, but they all share the same seal that says the District Court of the State of Michigan. So, anyways, I put into that case for Tammy an intentional tort of malicious prosecution against the United States for the IRS levying her property, using a simulated legal process. That was the idea. Well, that's a malicious prosecution. I don't want to argue the taxes. I want to argue that it's a malicious prosecution, make the United States come to court and answer, yada, yada, yada. Well, what happened in that is, of course, the United States Attorney's Office took the case out and put it into the federal district court. That's what it's supposed to look like. So I didn't want that to happen necessarily. So I said, I'm going to try to do something in small claims court next time. And the reason I couldn't do this one in small claims court is malicious prosecution's a tort, and you can't take torts in Michigan to small claims court. So you have all these little, details. Always a freaking detail. But let's look at these details a little bit. Yeah, just a real quick recap, right? So this was the Tammy's case in whatever court it is, the 84th Judicial District. Right, so there it is. Who's the defendant? Well, the United States is. Okay, and with the summons. And we got these addresses from, I can't remember exactly where I got them, exactly. I had to think about it a little bit, but you're supposed to notice the Attorney General of the United States separately, and then also the United States Attorney's Office. And we put in a complaint with some exhibits, and went from there. Okay, so what happened then? Well, sometime later, Tammy got this notice that the United States of America, now she was suing the United States, and now all of a sudden the defense of the United States of America, right, was doing a notice of removal based on these laws, codes, sections, United States Code. It says that, that it can be moved, but it wasn't against the United States of America. So anyways, this case is still sitting dormant in the federal court, and more on that some other time. I'm just saying, well, that's what happened in that case, right? They took it from the district court to from the Michigan district court to the U.S. district court, changed the name of the plaintiff, didn't sign any documents. There's nothing that they do in these cases. So here's an example, right? That it's in the name of David A. Hubert, which is nobody's name, signed by Edward J. Murphy. But David didn't sign in his name. So I don't know that Edward can sign, right? There is no Edward J. Murphy. It's not the guy's real name. So all sorts of errors in these things. Okay, continuing on. Hang on. Okay, so, one day when I had nothing else to do, I was looking through some laws of Michigan, trying to find something that had a damage amount in it that was, like this, damages of $200. Say, okay, well, that could be done in small claims. It's a small damage. Right? And I found this whole list of them somewhere. I should probably find that again. But they had this one, damages for forcible entry and detainer. Right? And when you read the first section, it says any person who is ejected or put out of any lands or tenements in a forcible and unlawful manner, or being out is afterwards held and kept out by force, is entitled to recover 3 times the amount of his or her actual damages, or $200, whichever is greater, in addition to recovering possession. And so, okay, well, tenements is like everything other than land, right? It's like all your personal rights. You got corporeal tenements and incorporeal tenements, and so it's everything. Your Social Security account, that's a tenement, right? Your citizenship in the United States, that's a tenement. All these things are your tenements. My pay or retirement as a veteran would be a tenement. So I said, okay, I've been forced out of all that shit. I've been forced out of my legal name. I go to court, they don't want to use your legal name. They want to use a middle initial or put your name backwards with a comma or whatever. And it's like, if somebody puts Rutluski, comma, Robert Allen, that's not my name backwards because my name doesn't have a comma in it. Right? So, it's signifying something other than my full legal name, which is the in personam name I wanted to go to court with. And this is the other thing, that when you go to, like, the real district court, as they would call it, you have to be represented, even if it's pro se, right, by an attorney. But in small claims, it's all in personam jurisdiction. Right? You're not represented by an attorney. So, now there is something that the defendant can do with an attorney, and the defendant can move the case to the district court and so forth. This is all in the rules, and this is part of what we're going to talk about here in just a second. Okay, so, I went ahead and filed a claim. It's called an affidavit in claim, small claims. Right, there's the case number, 2022 SC 122, where the plaintiff is Robert Allen Rutluski, full legal name, my address, and I used, what I would consider to be my residence address, because I live in Oakfield Township. But my mail comes from Rockford, so my mailing address is Rockford Township. Rockford, Michigan. Right? But, there you go. So the defendant was United States, care of the civil process clerk, United States Attorney's Office, at this address, yada, 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 city of Grand Rapids, Michigan. I had tried to So this is in this particular trying to file this, I've actually tried to file this 4 different times, and it's finally gotten to where I got a court case. But the first time I filed it into my district court, and they returned it all to me, and they said that it was the wrong court. I'd have to do it in the court of the defendant, and you know, either they told me that or I asked them, well, where is it? And they told me it's the 61st District Court, which is downtown Grand Rapids, which is in the area where the federal building is, and City Hall, and da 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 da. And actually, the 61st District Court is called the Court of the City of Grand Rapids. You know, that's the other name it's known by. So all the shit in the city of Grand Rapids, right, is subject to that court. It's the court that has jurisdiction in the city of Grand Rapids. And in the city of Grand Rapids is the federal building, and that's, you know, the house, the home of the United States. Okay, so who's who? I said I was a union member because I said that the defendant was a union, right, which it is. The Constitution says that, you know, the United States is a union. It may have a government, but, you know, it's a union, and I'm a union member. So, it's, you know, to me, this is like an internal grievance. Right, date the claim arose. Yeah, just pick the date. Renewing daily. Amount of the claim, $200. And so I said, you know, per that law we just looked at, that I've been ejected from Constitution of the United States protections, full legal name identification, electoral franchise, civil status, armed forces of the United States, veterans' pay and privileges, and enjoyment of my one share of the public trust, to name just a few of my tenements damaged by the United States' failure to provide the Republican form of government guaranteed to Michigan and the other states under the 4th Article of the Constitution of the United States, thus facilitating the forced entry of a foreign invader, the United States of America, imposing an unconstitutional democracy on the people of the United States and several states, run by children of the devil, impersonating as senators, representatives, members of the several state legislatures, executive and judicial officers of the United States and the several states, who falsely claim this nation is governed by a Jewish fable known as the Noahide Laws, and not the Constitution of the United States, as evidenced by 105 Stat 44, which is Public Law 102.14 of March 20th, 1991, of the 102nd Congress, and who are detaining my tenements. That was my reason. Right? So I'm saying, hey, that, right, defendant's not mentally capable, competent, because, well, you know, it's a thing. And I do not know whether the defendant is in military service, because, well, things could be used in military service. I know union members are in service. Right? All the soldiers are all union members. So this is what I filed. Took 4 times, but finally I got them to give me a hearing. Now, you know, it isn't that they did this completely correct, but the fact that they're actually doing it is what was interesting. Right? So now I get a hearing date, and it's supposed to be Zoom or courtroom 7B, but, you know, they didn't cross the box here and give an address, so I don't know where courtroom 7B is, because here it says court address and court telephone number. Well, there's nothing there. But I wasn't supposed to fill it out because I was supposed to start at 1. Right? So I just followed the directions. So this is something they should have done. And the process server's name should be the process server's name. It shouldn't be certified mail. You know, so already just on the first page, the court was making errors on it. So, you know, I had put this in, finally got this thing, and had been sitting since late March. And then last week I get a phone call from the United States Attorney's Office. Now I wasn't home it was on Thursday, and I wasn't home, and it didn't show on my phone that I got a call from the United States Attorney's Office. It's all it said was wireless caller. right? And then with a phone number that I could see, but when I listened to the message, it was somebody saying that they were an assistant U.S. attorney from the United States Attorney's Office, Grand Rapids, Michigan, wanted to talk to me about dismissing my claim because they said the United States cannot be tried in a state court, which isn't true. Of course they can, right? They could move it if they want to, but it's not that they can't be tried. And so that's so what was different there. Before we get into what I did about it afterwards, well, what was different there is they didn't do that with Tammy in her case, right? They just went ahead and moved it to the U.S. District Court. But they're calling me saying they want to, I have to dismiss my case, and that I can only bring it to the U.S. District Court. Well, no, I don't want to dismiss my case. Not unless I get some proof, right? So that's what I asked them for. So hang on just a second. Okay, so I got a call from Carrie Almayason, right? Well, thankfully, she did say she was assistant U.S. attorney, and you can go on to the on the state bar website and usually find these people, right? So I was able to find a Carolyn Ann Almayason from the U.S. Attorney's Office, right? And they had her email address. And, well, there you go. I'm not going to call her on a private number that doesn't say it came from the U.S. Attorney's Office, right? I'm not playing that game, right? You're going to call me, it's got to be official. So as you'll see, that's one of the things I was complaining about. But, here's what I said. Hey, Esquire Almayason, at 11:40 a.m. on Thursday, April 21st, 2022, I received a phone call from an individual claiming to be Carrie, or is it with K, Carrie Almayason, Assistant United States Attorney, with the United States Attorney's Office in Grand Rapids, who used the phone number 616-307-3346 to place the call. Caller ID associated with this number does not indicate I received a call from the United States Attorney's Office, but instead simply displays wireless caller. Esquire. Using a private phone number for official business in the United States is as much a national security threat as Hillary Clinton using a private email address while Secretary of State. It could even be construed as disloyalty to the United States and subject to court-martial proceedings. If it was not you who called, then please inform the United States Attorney for the Western District of Michigan of the possible impersonation of an officer of the United States and the use of a common carrier for fraud, the same being offenses against the United States. As for the substance of the call, the caller wanted to discuss a dismissal of my claim against the United States based on the caller's unsubstantiated statement that the upcoming hearing was in a state court. In reply, I require the following proof before I would voluntarily dismiss my case. First, cite the law that legislates the United States cannot be sued in a state court. And secondly, I will need you to provide the 61st District Court, or to prove the 61st District Court is a state court, by your obtaining the record or certificate required by United States Code, Sections 4 U.S.C. 102, of all executive judicial officers of the state, proving they said officers executed the oath in 4 U.S.C. 101. And if you've watched my videos, you know what I'm talking about. Title 4, United States Code, Section 101, as we'll read in a second, has oath in there that all state officers need to take. Right, so for clarity, I gave her a link that she could have her own authenticated copy, because this is coming off of the govinfo.gov website. So it says right in the top left-hand corner that that's an authenticated copy of, what it is. So, and the following is the text of these subsections. So what does 101 say? Well, it says the oath by members of legislature and officers. Every member of the state legislature and every executive and judicial officer of a state shall, before he proceeds to execute the duties of his office, take an oath in the following form, to wit, I state your name, do solemnly swear that I will support the Constitution of the United States. Right? Now, I said in the following form, to wit. So they have to do it exactly like this. There's no deviation from the form. Right? It was legislated that this is the form of oath that they needed to take. And the AB is where they would have to stick in their full legal name. Right? So they can't just say, I do solemnly swear. It needs to be I and a space to put their name in, do solemnly swear. You know, that has to look like that, or it's not the oath that they're talking about. And then 102, it says, saying by whom administered, such oath may be administered by any person who, by law of the state, is authorized to administer the oath of office. And the person so administering such an oath shall cause a record or certificate thereof to be made in the same manner as by law of the state he is directed to record or certify the oath of office. So they got to have a certificate or a record to prove they took the oath of office before they can execute any of the powers of the office. Now, this goes all the way back to this one of the early court cases, which was Supreme Court cases, which is Marbury versus Madison, which they always make it a big deal about it being about judicial review. But what it was a really big deal about is it was proving that if you don't have a certificate to prove you took the oath, you can't exercise the powers of the office. And that's what Marbury was trying to get from Madison. He wanted to get his frickin' certificate so that he could be a justice of the peace. Because without it, he couldn't be one. So by the same manner, the people down, at the courthouse, they can't be a state judge unless they've taken this oath. They can't be a prosecutor unless they took this oath. They can't be the governor unless they took this oath. And as I've shown over years now that, they haven't done it. So obviously, if you cannot obtain this proof, I have no interest in dismissing my claim for the reasons given to me by the Thursday caller. I'm not really sure who it was. Doesn't say on caller ID that it was the United States Attorney's Office. Could be an imposter. So for the record, I would be overjoyed to dismiss my claim if the United States compensates my damages, redresses my grievances, and administratively restores my tenements without the need of judicial coercion. In the alternative, I will see the United States judicial or executive officer in court on May 2nd, 2022. Please tell the United States Attorney to ensure the officer representing the United States has their record or certificate filed as evidence in the case to prove they executed the oath that satisfies the 6th Article of the Constitution of the United States as legislated in an act to regulate time and manner of administering certain oaths. 1 Stat 23. Right? 1 Stat 23 or USC 101, they go together. One's like a derivative of the other. 1 Stat 23, very first very first act passed into law after the ratification of the Constitution. And in it says that this oath, the one that we just read, basically, it's the same oath, right? Right here, I, do solemnly swear I support the Constitution of the United States, is the oath that satisfies the 6th Article of the Constitution. And I got to say something right now. I hear a lot of, I can't say a lot, but who's the representative from Georgia? What's her name? Right? She's talking about back to 1776. We're not going back to 1776. We're going back to 1789. That was when the Constitution was ratified and the very first law passed. And it said, you want to be an officer of the United States or a state officer, you're going to take this oath. Now, if they don't take the oath, and they're supposed to take the oath because it's required by the Constitution and the laws of the United States, well, then it's called avoiding a loyalty oath, right? And that is an act of treason. So take judicial notice. Officers of the United States, imposters, will be charged with treason against the United States for avoiding this loyalty oath. Regards, that would be me. And Andrew, hey, you're concealing your full legal name in an official capacity as an officer of the United States. The Real ID Act mandated the only full legal names that are to be used for official business in the United States. Please square yourself away. Right? Because on the bar website, it's Andrew V. Burge. Or actually, on the government website, on the Department of Justice website. Well, that's not your name, brother. Right? That's not your full legal name. You didn't get your license under that. You're not licensed, or you're not allowed to practice in the court under that name. Right? The court's got your name in their log with your full legal name. Right? So you're concealing your identity, and in a time of war, that could be considered an act of a spy. So we'll see what happens, right? I got a call Thursday. I sent this, in a week from Monday is when the court date's supposed to be. And we'll see what they do, during this week. Because the thing about this, I guess maybe I didn't say this, talk about this much here. Go back this real quick. The thing about forcible entry and detainer is it's not a tort like a wrong against an individual. It's a crime against the state because you use force to do it. Right? So the United States would be going to court for committing a crime, even though it's small claims court. But, that's what we're talking about. Forcible entry and detainer is a crime. It's not a tort. So I'll just show you a few things. We'll look at the court case here in just a second, too. Hang on a second. So when I was filling out the small claims form, right, they had this guide, Form DC-84, Affidavit and Claim for Small Claims, right? How to get a money judgment in small claims court. Well, the statute made it a statutory damage of $200, which is a small claim, so I can put it into small claims court, and because of the amount that it is. It's $30 to file a claim. Now, let me see. What was the thing here? You cannot use small claims division of a district court if your case is against the state of Michigan or a state agency. No. Your case is against a local government unit, involves issues of government immunity. No. You are an assignee or third-party beneficiary of an obligation. No. You have filed more than 5 small claims cases in a week. No. There was something here about it being a tort, too. I have to go find that again. But, again, a tort is against an individual, where it's a wrong against an individual, where a crime is a wrong against the state. So it's not a tort, it's a crime. And I said after you filled it out that you could mail it in, and then you get down to here to prepare for trial, right? To prepare for trial, gather the evidence you need to prove your case. A letter or affidavit of a witness will be accepted as evidence by court without the witness being physically present at trial. Witness is unwilling to appear. You can ask the clerk to issue an order to appear, requiring the witness to appear at the trial. The order to appear must be served on the witness no later than 2 days before the trial. I may have to subpoena somebody this week. I have to think about that. Okay, so, just put it in and see what happens. Excuse me. So now I was saying, okay, well, now I got to get all my evidence together. Right, and, so some of that, obviously, is things like what Title IV says, right? We're oath of members legislature. So, if we have a Republican form of government, then they're supposed to be appointed or elected officers enforcing written laws. But we don't have those. Because to be appointed or elected, they would have to have the oath of office, because you're not done until you get the certificate. And there isn't anybody who has a certificate that shows who took this oath. Now, what I did, right, so I said, okay, I'm going to go down to the library and print these out. and get the library to put their stamp on it so I can say that this came out of the public record. Right? That, Retluski didn't spend all night writing this up himself to make it look like it's legal. No, I went to the public record and got a copy, and, here's my proof. And outside of the Spencer Township Branch Library is a flag of the United States, a Michigan flag, and a POW flag. I'm covered. If I'm any of those, I'm covered. I say I'm considered a POW, or missing in action at least, because I've never gotten a discharge order, but the Army acts like they can't find me. Okay, so then I'll get one stat 23, because that's the one for all federal officers. Right? Again, they were happy to do it. Right? So I would say if you're going to court, you got to put in some kind of document that you want to use as evidence. Right? That you need to go to the library and print it out there from their sources and have them put their stamp on it. We'll see if it does any good. But right, and just real quick here, so that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the following form, to wit. IAB, do solemnly swear or affirm I will support the Constitution of the United States. Right, and it goes on in here to say that they have to make a copy or, have a certificate. And, well, since Marbury versus Madison, if you don't have a certificate, you're not holding the office. But if you try to exercise the powers of the office without having the certificate or having taken the oath, well, that's avoiding a loyalty oath. And since the time of Henry VIII, that has been an act of treason. And then I wanted to show that, well, so this is this is the executive order from 2020, number 4, that started the state of emergency in Michigan for COVID way back in March of 2020. Remember that? Right, where Governor Gretchen Whitmer. Well, that's not her full legal name. Right, so who is she? And then she told some lies in here, about who this guy was. That, United States Department of Health and Human Resources, or Health and Human Service Secretary Alex Alazar declared a public health emergency. Well, that isn't the guy's name. He's like a junior or senior or somebody, right? That's not his full legal name. Anyways, but you get down here and it has a seal on here. And if we were to look at it closely, it says the Great Seal of the State of Michigan. It's all in all caps. Hang on just a second. Starts with the. It's all in all caps, and it's got a date, AD, Roman numeral date on the bottom. Wasn't that something? Where's that law at? Hang on a second. Now here's the Great Seal Act of Michigan. All right, where it says the Great Seal shall be comprised of a coat of arms of the state around which shall appear the words Great Seal of the State of Michigan. All of it in lowercase, and it doesn't start with the. So this seal here is a counterfeit. Right? This isn't the state of Michigan. This is somebody impersonating the state of Michigan. Who is Gretchen Whitmer the governor of? Because she's not the governor of the jurisdiction that has this great seal. She's claiming to be the governor of the jurisdiction that has this great seal. Well, I don't claim to be in that jurisdiction. That's not the one under the Constitution. And this is the only oath that she's filed. I mean, I got this from, the Michigan Elections Division. It shows it was received and filed with the Michigan Department of State, or Depth of State. Right? Governor. where they've changed the grammar of the sentences by changing the capitalization of the words from what's in the Constitution. But we'll save that for a different time. Right? Gretchen Whitmer, well, that's not her name. Her name is Gretchen Esther Whitmer. And, this was done by a notary. Well, it turns out in Michigan that we look at who oaths of office authorize individuals who may administer oaths, right, for the Michigan.gov SOS. Hey, came out of the public record. You can ask the township library, where it says all offices, right, that a notary public can take an oath for, with the caveat 1, and 1 says that excluding governor, attorney general, secretary of state, lieutenant governor, or members of the state senate or state house. Okay, well, that means she couldn't do Whitmer's. And yet here's a notary doing the oath for Whitmer. Well, then she's not the governor of Michigan. She's an imposter. Right? And these imposters have the democracy, which is not in the Constitution. There is no democracy in the Constitution. There's only a Republican form of government. And yet that's, the ones that are detaining my property right now. Okay, in a minute here, we'll go to the court website and look at how they have this all put into the, into their docket. Look at all the errors and omissions. These are all things that I'll be contacting the clerk about next week. Because one of the things is that, in the instructions it said to bring your evidence to court, but I have a Zoom hearing. Well, how do I get my evidence into the court case then? Right? So I'm going to have a busy Monday getting a few things figured out. But I wanted to show you, right? This is the 61st District Court right here. And this is like downtown Grand Rapids. And, this is like ground zero for all the stuff that happens in, right? This is the federal building here, right? So this is where the U.S. Attorney is. And, right, the Court of Appeals, the federal building, Gerald R. Ford Federal Building, U.S. District Court, all this stuff, right, the Kent County Clerk, City of Grand Rapids, all of these entities are in the jurisdiction of this court right here. Right? So if there's a crime being committed in this jurisdiction, you're supposed to bring it to the 61st District Court. And I'm saying, you could do a lot of things under, this unlawful detainer because they're withholding your tenements from you. But anyways, that was the start of this. And this is why when I sent it to my court, they said, no, you need to send it to the defendant's court, which is the 64th District Court. Well, why would that be? Well, it's because just up the road over here, a couple hundred yards away is the federal building with the offices of the United States District Attorney. Very good. Okay, and then a little bit about forcible entry detainer. Just read just a few things. That it's a summary proceeding for recovery of possession of land that is instituted by one who has been wrongfully ousted from or deprived of possession. Now it's land and tenements. Forced entry and detainer, one aspect of which is known as unlawful detainer, alludes to two separate misdeeds and two divergent remedies of statutory origin. The forcible intrusion into another person's peaceable possession constitutes one type of infraction. Even if it is unlawful, peaceable possession cannot be terminated by violence. In many jurisdictions, even the rightful owner is held liable for damages which are provided by statutes, are often multiple in nature if he or she employs excessive force in ousting one in peaceful possession. In such instances, the offense involved is the force itself and not the actual dispossession. The second form of misdeed entails the initiation of legal proceedings by the rightful owner against a squatter without title or a tenant who declines to depart. Force in such instances might be inconsequential, figurative, or non-existent. Damages are avoidable, but the restoration of the lawful owner to possession of the property by eviction of the defendant is also within the purview of the remedy. This remedy, which awards both damages and possession, resembles ejectment, which also entails a recoupment of possession of property, the person entitled to it, but significant differences exist. And I think that what that is because by ejectment you have to go to trial, right? Jury trial. But forcible entry detainer is a summary proceeding, right? The judge can make this decision on the frickin' bench. So, I'm saying that the United States is they're a conspirator in the United States of America detaining my property. We'll see what they have to say about that. Just a real quick recap on a couple of sections of the Constitution that are so important in, what I'm trying to do. Other people have their own sections they want to look at. But I always hear people talking about the amendments. It's like, dude, you got to get through the articles first. If you can't get through the articles correctly, there are no amendments. And in the 6th article, it says in the 3rd subsection that the senators and representatives before mentioned and the members of the several state legislatures and all, A-L-L, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Well, in the section just before that, it said that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution laws of any state to the contrary notwithstanding. Well, it's positive law that 4 U.S.C. 101 is a law of the United States. And because of that, it says that all state officers have to take the oath that we looked at. So if the United States Attorney's Office wants to say, well, I took it to a state court, they're going to have to prove to me that the judge hearing the matter has taken the proper oath of office. I don't have to prove it. They have to prove it. They're the ones who said it was a state court. Wonderful. I mean, that's check. Now, I don't know what their move is, but, hey, check. And then in the 4th section, right, in the section 4 of Article 4, the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or the executive against domestic violence. Well, that's what, the United States violated its guarantee. Where is our Republican form of government? Where is Michigan's Republican form of government? That's what they need to give me. It's part of my relief. And so, okay, well, what if they don't? Da-da-da-da, yada-yada, all the what-ifers, and it'll never happen, and, I don't really care. I just do it anyways, right? I make them have to witness against themselves before the Lord that I showed them the truth, and they decided, to act in bad faith. So, but what I'm going to do, now I didn't realize this until just here recently, and it was pointed out to me that on the top of the Army Sworn Statement form, which I've shown in many videos, DA form 2823, if you Google that, you can see a copy. It says at the top that it's under the authority of the PMG. And the person that showed it to me said, well, does that mean Postmaster General? And I said, well, I don't know. So they look, PMG. Oh, no, there's a Provost Marshal General. That's who it belongs to. Right? So the Army Sworn Statement form is, a device of the Office of Provost Marshal General. And you can easily find their site by just Googling it. And if you're a veteran, for sure you should do this. But if you're in any kind of court case, you should do this. And I'll do a video on it after I've done it. I just found this. And it's like, well, yeah, we should be doing this. Right? So you go to this website, and you go down here to reporting links, and you click on I salute. Right? If you have information that may be of interest to U.S. Army counterintelligence, please continue to submit an I salute suspicious activity report. If you do not, click cancel. You may also report by telephone at some phone number. All right, let's just continue because I'll be doing this at some point. By clicking continue, you have indicated you wish to report a suspicious activity in accordance with Army Regulation 381.12. Yeah, why not? Threat Awareness Reporting Program. And wish to be contacted by U.S. Army Counterintelligence. Yes, I want to be contacted by U.S. Army Counterintelligence. If you have an emergency, call 911. Okay, so what type of incident do you wish to report? Well, what do we got? We got insider threat, espionage, terrorism, sabotage, surveillance, suspicious contact, security compromise, sedition, treason, subversion. Well, yeah, if you avoid a loyalty oath, that is an act of treason. And so, if the United States Attorney's Office attorneys didn't take the oath to satisfy the 6th Article of the Constitution, that is an act of treason. Or if you're going to court, any court, and they're taking your property, right? Which is, I think that's in the Fifth Amendment. We should probably go look. We will in just a second, right? If they're taking your property, they're denying you due process if they haven't taken this oath. Right? That's an act of treason. If they avoided taking the oath, it's in 4 U.S.C. 101, and they're claiming to have authority to take your property, well, that's an act of treason because they avoided the oath. So take the judge to the frickin' and report him to the Army. Now, how do you know if he has the oath or not? Right? Well, the easiest way is to go to the county elections office. Would be the first place I would start for, your county, or go to the Secretary of State. And so go to both of them and ask them both for the same thing. And whatever you get, you get. But if you don't get the oath that satisfies 4 U.S.C. 101, then it's just proof they don't have it. Right? They're supposed to have the proof. You don't have to actually go look for it. They're supposed to have it. Okay, hang on just a second. Because I wanted to show you in this Marbury versus Madison, right? 5 U.S. 1, crank 137. U.S. Supreme Court case that established a principle of judicial review in the United States, meaning that the American courts have the power to strike down laws and statutes they find to violate the Constitution of the United States. I got to find out how to do that in my next thing for somebody. Decided in 1803, Marbury is regarded as the single most important decision in American constitutional law. The court's landmark decision established the U.S. Constitution is actual law, not just a statement of political principles and ideals. It helped to define the boundary between constitutionally separate executive judicial branches of the federal government. And let me see, where did it talk? In a fiercely contested U.S. presidential election, 1800, 3 main candidates, Jefferson, Burr, Adams. Where is it? Okay, the day after, on March 4th, 1801, Jefferson was sworn in and became the 3rd president of the United States. Jefferson instructed the new Secretary of State, James Madison, to withhold the undelivered commissions. In Jefferson's opinion, the commissions were void because they had not been delivered before Adams left office. Without the commissions, the appointees were unable to assume the offices and duties to which they had been appointed. Over the next several months, Madison continued to refuse to deliver Marbury's commission to him. Finally, December 1801, Marbury filed a lawsuit against Madison in the U.S. Supreme Court, asking the court to force Madison to deliver his commission. This lawsuit resulted in the case Marbury versus Madison. Right? So anyways, the court then confirmed that a writ of mandamus, a type of court order that commands a government official to perform an act their official duties legally require them to perform, was the proper remedy for Marbury's situation. But this raised the issue of whether the court, which was part of the judicial branch of the government, had the power to command Madison, who as Secretary of State was part of the executive branch of the government. The court held that so long as the remedy involved the mandatory duty of a specific person and not a political matter left to the discretion of the courts, could provide a legal remedy. Borrowing the phrase John Adams had drafted in 1779, Marshall wrote, "The government of the United States has been emphatically termed a government of laws and not of men." Well, okay, well, that's what I need, right? I need a writ of mandamus, because I don't write a writ of mandamus. I apply for a writ of mandamus, and the court issues a writ of mandamus, which is an order. Right? It's an order ordering somebody to do something. And, you know, I got myself lost here a little bit. Here we go. Right? So they need to order a government official to restore my privileges. I don't need to know what they are. That's for them. They need to know what my relief is. I'm just saying this is what's happened. Right? And so some of the other proofs that there are that I've talked about in the past is if you look at your birth record, right, which people want to call a birth certificate, but, you know, almost everyone I've ever seen has been, really, it's called a certificate of live birth, a COLB. Right? It's not a birth certificate, and that is what they say in the law is birth certificate, but you have a certificate of live birth. You were given the wrong fucking document. And, you know, not only is it wrong, it has errors in it. It really doesn't have any legal value. If you look at the date that your birth date and the date that the local registrar received it, you know, like on mine is 13 days, but the law says that the state registrar had to receive it within 5 days, and they get it from the local registrar. So the local registrar would have had to have it within 5 days. Didn't happen. So, you know, it's an invalid document. And, you know, in Michigan, I've shown in a video that you can go download the Vital Statistic Act law, right? And then do a word search on certificate of live birth, and it'll show you all the places it's used in the law. And all the places it's used in the law in Michigan is for adoptions and born out of wedlock. In Illinois, it's for adoptions, born out of wedlock, and stillbirths. Right? But it's not, you know, for you, if you were, you know, the nuclear family type thing. It's a document that shows that you were adopted. And it has errors in it. So, nevertheless, if you were adopted, and that's what the record shows, well, then who's supposed to be your, you know, your parents, co-parents? Obviously, it would have been, you know, the state and the United States. Or maybe the United States of America and the United States. The Union. Not really sure what it is, but what I know is I'm not in the democracy of the United States of America. And none of the people that are have taken the oath of office required by the 6th Article of the Constitution, so they're not the Republican form of government that was guaranteed to the states. And, okay, so real quick, we'll go look at the court case. Hang on a second. There's lots of errors on the pages, but let's go see what it looks like. All right, so Grand Rapids, 61st District Court, right? Doesn't say Michigan anywhere. This is Grand Rapids, 61st District Court. Case number 2022 SC122, right? So anybody could look this up. And who's the litigants? Well, it's Rutluski, Robert Allen, which, you know, I'm not really happy with, but that's the way they did it. But it does say United States, right? It doesn't say United States of America. It says United States. Now, we're going to look at some things in here, but before I forget, I wanted to show one other thing because this all ties together. So hang on. Yeah, the biggest thing I had noticed is they don't like to fill in any blanks. So I click on my name and I go to litigant information, case information, right? It's plaintiff. Don't have any status. If you click on it another time, it takes you even one step further. And this is where I'm going to be complaining to the clerk because, here's the party details. Well, they don't have a mailing address for me, or residence address, or birthplace, or street. They have places for all that information, but none of it's in there. So they're really not identifying me nearly as, accurately as they could. There's no social security number in here. You know, and. It's like, hey, man, if it can be put in there, I want you to put every detail about me in so we know exactly who it is you're talking about. I want them to tell me what my residence address is because I don't know what it is. No one will tell me. Right? You're the court. You tell me what it is. Or make whoever is supposed to tell me what it is tell me what it is. Because it's not Rockford, Michigan. I don't live in Rockford. That may be my mailing address, but it's not my residence address. Right? And then you go here, it says addresses, and it has a 1. So let's just click on that. And there's nothing there. What's my address? Blank. Right? This is intentional. These are errors and omissions in records that they can later tweak to their own freaking advantage. What's that say? Entered on 3/22. Okay, what'd you enter? Nothing. What's this one say? Right? Address. It's all blank. Didn't say I had a bad address. Didn't say I had any address. I wonder if I can change that. No, I can't change it. All right. So any aliases? Well, they don't have any on there. Estimated something or other? Nothing. And here, look, hearing. It says 1, but they actually have 2 hearings scheduled. One at 1:30 and one at 2. One in small claims, and then one, under this small claims number. And then another one for Robert Allen Rutluski versus United States at 2 p.m. upstairs somewhere. So I got 2 different court cases, or 2 different cases to be at, a half hour apart, but that isn't what it showed on the, the original complaint. It just shows 1:30 p.m. at Zoom or courtroom 7B. Well, how can I be at both? Which one is it? This is where they've put all these errors and omissions in their records. Right? We have no history yet. So it'll be interesting to see what happens next. But, you can't deny that it's one of the parties is the United States. Right? But as far as this court's concerned, the Grand Rapids 61st District Court in small claims before Stephen A. Brunick in courtroom 7B on the 7th floor at 1:30 p.m. There's to be a hearing between Robert Allen Rutluski, it's my full legal name, and the United States. It doesn't say United States of America. It says the United States. Well, they didn't have any problem scheduling the hearing. So, apparently I could bring a claim against the United States in this court. Because when I tried to bring it in another court, they said I had to bring it to this court because this is the court where the United States office is within the jurisdiction of the 61st district, and I'm in the 63rd district. Duh. Right? So somewhere downtown in your county seat is where all the stuff is, federal building, whatever there's going to be. Right? Or, maybe you have to go to the like in my case, right, that you would have to go to Grand Rapids because that's where the court is for the federal courts. So I don't know if you can just do it at your local small claims or not. You find out, you put it in and see what happens. So we'll find out. I mean, this is all happening right now. This could, come Monday, they can say, hey, look, we've moved it to the federal court. There's nothing you can do about it. And, it's going to squander there forever. But in Tammy's case, they didn't tell her, they didn't call her and say, hey, you need to dismiss your case. They just went ahead and moved it. In mine, they called me and said, well, you got to dismiss your case because you can't try the United States in a state court. Well, that isn't what the law says, right? The law says it can be moved to the district court, but it doesn't say it can't be tried in the state court. And I'm going to say, okay, well, you're the one who said it's a state court. Prove it. Prove to me that that man sitting there as a judge in this court is taking the oath to satisfy the 6th Article of the Constitution. And if you can't, well, then it's not a state court. And, there goes your argument. I'll see you in court. What I would love him to do is, let's settle out of court. Let's just say, hey, that's correct. This is what you needed to do. You needed to bring the United States to court like a small claims and petition for redress of grievances. Something like that. We'll just get the words out of what we need to do from now on, and, then that's what we could do. Okay, I'm going to leave it there. Everybody have a wonderful Orthodox Easter, and I'll let you know what happens. Oh, no, I had one more thing to show you. Jeepers, I keep saying that. If you look at this DA form 2823, which is a sworn statement, and you go to the 3rd page, right, the thing you're really swearing to is this right here, this affidavit part, that you have read the above, right, and understand the contents, and yada, yada, yada. And now you're going to have it all done with witnesses and so forth. Well, they have something similar in the state. They call it a self-proving affidavit or self-authenticating affidavit or some other kind of name. And in Michigan, they call it where are you? A self-proved will, right? Lowercase will. You look up will in a dictionary, it's got all sorts of definitions, such as, just you expressing your intentions. That's your will, right? But if you do it as the will of a testator, well, that's the will of a dead man. So you'd have to change testator to whatever you were, like injured party or, affiant, whatever word would be the proper word. I'd say probably affiant, where you're going to be filling out this, I, the affiant, sign my name to this document. I have taken an oath administered by officers whose signature and seal appear on the document, swearing that the statements in the document are true. Right? You're swearing to a sworn statement. I declare that the officer of this document, I declare to that officer that this document is my will, and I sign it willingly and willfully direct another to sign for or direct another, and that I sign it willingly or will willingly direct another to sign it for me, that I execute it in my voluntary act for the purposes expressed in the will, that I am 18 years of age or older under no constraint or due influence, and that I have sufficient mental capacity to make this will. Right? It's just you can't be the testator because the testator's a dead man. Right? Now this is where the witnesses come in. And then this is where it's all sworn before get rid of the word testator, but it's all sworn before the official capacity of the officer. Now, does that mean a notary public can do it? Is that an officer? Because this is done through probate. It's made for. So do you need to go to a probate attorney to have them do it? I wouldn't think you would have to. I'm just saying, right, that it's this style and, verbiage that makes it what it is, and that this is the same as what's at the bottom, not the same wording, but the same idea as what's at the bottom of the sworn statement form. It's not your statement. Your statement's up here. You're going to say whatever you're going to say, but then you put this at the bottom. And you, the affiant, right? Signature of the affiant. Document as the affiant executes the document. All right, so forth and so on. So I'm not really sure how to use it. I'm just saying, this is the same thing as what the Army Sworn Statement form is. So maybe we could use this instead of trying to use an Army Sworn Statement form and just make sure you fill in all the blanks and put this at the bottom of your statement. And now it's self-authenticating evidence and can be submitted into court without any other proof of what it is. Right? It's the whole idea of self-authenticating evidence under Rule 901 and 902 of the Rules of Evidence. Right? A self-authenticating document under the rule of the law of evidence in the United States is any document that can be admitted into evidence at a trial without proof being submitted to support the claim that the document is what it appears to be. Okay, admitted into evidence at a trial. Well, can the clerk admit it into evidence before the trial to be used in a trial, or do you have to wait to the trial and say you wanted to admit it into evidence? But either way, you have to have it in the court case so it can be admitted into evidence. It's not hearsay. This is self-authenticating evidence now. So it is what it is. It's your sworn statement of the facts. And so if somebody wants to rebut your sworn statement of the facts, then they're going to have to swear to their statement of the facts on why yours are wrong. And they won't swear to it. Should be the same as, well, they won't sign their documents, right? Then they have to have it removed. But you won't swear to your statements, then you didn't make a statement. You just simulated a legal process. Okay, very good. I'm going to leave it there. And again, everybody have a great Orthodox Easter, and we'll see where we are next week. See you now.